Hi, my name's Phil. I like talking about politics, and it's almost like trial of the century. The Supreme Court hearings into whether or not Boris Johnson's particular method of proroguing Parliament, or the length of it, or anything else to do with it, is illegal or not, has started today with representations from Lord Pannick QC, who represents Gina Miller, and Lord Keane QC, who is representing the government, setting out a number of arguments, and Lord Panik for against the government set out a number of very strong cases. So what I'd like to do in this one is go over a few little introductory things to set the scene, and a few little whimsical moments. Then I want to go over the main points as I saw them today, the main arguments for and against, and leave it there. Now, I've called it Supreme Court Day 1. There's technically 2 other days. I don't want to promise there's going to be a day 2 and 3, because although I'll have way more time on Wednesday and Thursday than I've had tonight, they might be boring. They might just be dull as ditch water. It was actually really interesting today. So we'll just see how we get on with it. But first, if you find yourself enjoying the video, don't forget to click the like button and subscribe to the channel, please. So first of all, Supreme Court. We don't hear about cases like this very often, or when they do, they're mostly unremarkable for most of us. There are 12 Supreme Court judges, but at any one time, you would have a maximum of 11 of them sitting, so that there's no deadlock. You can't have a deadlock in a situation like this. However, even having as many of 11 of them sitting for one hearing is very rare. In the 10 years since the Supreme Court has been active, that has only happened once before. The only other time happening a few years ago, when Gina Miller brought her case against the government, concerned with the triggering of Article 50, which of course she won. So before we get started, legal arguments presented. A lot of us don't spend a lot of time in court, unless of course you are someone who works in the legal business, I suppose. So someone posted some things I thought was quite amusing, and it was like the sort of things you might hear in court with a tongue-in-cheek translation of them. So there's 10 of these. I'd like to go through these first. First one, if they say, "If my learned friend is right," translation for that is, "My learned friend is wrong." "I've just noticed the time." Translation, "I'm hungry. Are you hungry?" "I won't read it aloud." Translation, "It's really quite long." "As we set out in some detail." Translation, "Get comfy. This could take a while." "My learned friend has already made reference to." Translation, "Don't make me do it again. We just did it 5 minutes ago. Spare us." "Our strongest point." Translation, "This bit is a doddle." "If I may return to that." Translation, "This is tricky." "As the court might be aware." Translation, "I suspect you are completely unaware of this, and it will blow your socks off." "If I might venture." Translation, "Hold on to your hats. I'm about to go completely rogue." And finally, "Indeed." Translation, "I don't know what to say, but you're all looking at me." So anyway, on to the points. So the person opening up, as I said, we had a Lord Pannick QC representing Gina Miller, representing us really, and then Lord Keane QC representing the government. And I had to say to this my girlfriend tonight, I'm afraid I've got to do a terrible pun, because Pannick QC did not panic, but Keane QC did not seem all that keen. Let's go into the main argument. So it was Panik up first who was attacking the prorogation. So he began by talking about, first of all, the extraordinary length of time, this 5 weeks. He also made it clear that it was extraordinary that the Prime Minister has not made a witness statement explaining why he advised the Queen to prorogue. You know, that statement could have even been made by the Cabinet Secretary. Now, it's perfectly obvious to anyone the reason for that, because it's so simple. You know, if he's saying that, you know, well, my reasons are very clear, these are my reasons. Fine, write them down, sign it, submit it to court. The reason he doesn't want to do that is because if he writes down his reasons in any other context, whether he's writing them down for the Queen, for the Privy Council, for Parliament even, or for the public, and he's found out to have lied, that's not illegal. That's not illegal. But if he does it in a sworn affidavit, then it becomes illegal. Then he goes to jail. Do not pass go, do not collect £200, Mr. Johnson. That is the sole reason why he hasn't done it. Everyone knows that, but that was one of the early points made. The other thing is that Panik was quoting Boris Johnson saying that the best way to leave with a deal is if the EU thinks that Brexit cannot be blocked by Parliament. So it's pretty clear that Boris Johnson sees Parliament as a threat to his policies. And that's why he has suspended it, to stop Parliament being able to exercise their duty, never mind rights. Now, the other thing is, again, he was making the point that prerogative powers, and this power to prorogue is a prerogative power. What that means is it's really a power of the Queen that is in reality the Prime Minister's to exercise. So that's why the Queen sort of had to prorogue when she was asked, because although it's technically her power, the Prime Minister as the elected official in this scenario is the one who actually gets to decide when it's used. But what Panik was noting is that this prerogative power it has to be used for a proper use. And in this case, it has been used for an improper use. And he cited a case of where it was declared unlawful to use it as such. And he also brought up Gina Miller 1, the original Gina Miller case, which established that ministers could not trigger Brexit without legislation. And that proved that ministers are the junior partner to Parliament. So should ministers be able to remove scrutiny by the senior partner, Parliament? He said that's the real issue in this case. And he also, there were a couple of things he said that I thought were truly brilliant. Now, I am not a legal expert, so I don't know what effects that has on the judges, of course. But from my point of view, I thought it was brilliant. So one of the 11 Lord Justices, was a Lord Reid, who is the deputy of this panel. In fact, he's going to become the president of the Supreme Court when the current president retires. She was also there leading it as well. Lady Hale, I think it was. And what he noted was that this Lord Reid, in a previous case that he was overseeing, it was to do with a union case, Unison, and to do with tribunals, employment tribunals. And the complaint was that the employment tribunal fees were too high, so people weren't able to access justice. And Lord Reid, in this particular case, was able to rule that actually the employment fees, that the tribunal fees were too high to be lawful, but he didn't have to say what the limit was to be lawful. Because the tricky thing here is, what's been asked of the court is, they're asking the court to say that 5 weeks is too long. But the government side would argue, well, what's a reasonable time then? What is the legal limit? Because there isn't a legal limit stepped down in statute. What he's pointing out is that in a comparable case, it will be possible to say that 5 weeks is too long without having to say what the legal limit is. So the court won't have to be hamstrung by that, which I thought was very clever. The other thing is that Lord Reid then sort of pointed out, because the judges talk back, of course, it's very much back and forth, that Parliament, and this is the argument, if the Supreme Court ultimately find in favour of the government, ultimately I reckon this will be their overriding reason. He pointed out that Parliament could have blocked the prorogation itself if they'd wanted to. He said they could have done it earlier this month. I don't think that's as reasonable as saying that they could have done it over summer, which is when they bloody well should have done. And I had an idea about what they could have done, about other people have. I've now settled on what I think is the best way to have done it, which is basically what Parliament should have done was to remove an awful lot of prerogative powers from the Prime Minister. Just get rid of a load of them. So with prorogation, for example, it should be Parliament that votes on it, not the Prime Minister alone. And they should limit it to 1 week. You never need more than a week, ever. Some prorogations have taken place for longer than that, but you never need more than a week. So they should have limited it to a week. Or they could have added a little clause into the Act and said, unless Parliament votes for a longer period of prorogation. But the bottom line is they should have made sure that the timing and the period of prorogation were for Parliament to decide. They could have done that. They could have done that. However, Panik came straight back on it, not to be deterred, and says that that is no answer to the accountability of the Prime Minister for the legality of the conduct. What he's basically saying here is, If his actions were unlawful, the fact that Parliament could have stopped them does not stop them being unlawful. I suppose the analogy there would be if a police officer sees someone behaving suspiciously outside someone's home and carries on walking past, and that person still that breaks into that house, the fact that the police sort of effectively allowed them to do it does not stop the break-in being illegal, I guess is the analogy there. He also, now the government had been arguing that there have been prorogations of very long periods of time as well. And Panik wasn't having any of that. He said that for a start, all these cases were in the early part of the 20th century before the judicial review. So when Parliament would have had no recourse. And also, he said, in each case, they were not intended to prevent Parliament operating. And then he was corrected by Lady Hale saying, you mean the House of Commons, not Parliament? Yes, okay. But that was the thing. It was not there for the purpose of stopping the House of Commons scrutinising the government is the key thing. And he again made the point that he's not challenging the existence of the power to prorogue, because he can't, obviously. But he says the Prime Minister is not entitled to prorogue for a period so long that it has the effect or even purpose of frustrating the constitutional principle of parliamentary sovereignty and supremacy over the executive. And it comes back to this again, and this is what's been made clear time and time again, not just in this case, but in the past Supreme Court case, that Parliament is supreme over government. That is clear in law. Then Lord Hodge, one of the panel, asked, can the Prime Minister prorogue for political advantage? Now, this presumably will be a reference to when John Major did it for political advantage. So Panik then said, well, it depends, doesn't it? Lord Kerr, another one on the panel, said, but the point is not to avoid the scrutiny of the executive, to which Panik replied, precisely. And that is the key point. He's not saying that it would be unlawful to use it for political advantage. He's saying that it would be unlawful to prevent Parliament carrying out its duty to scrutinise the executive, is the key point. Then this, for me, in his summing up, before it was the afternoon of the government's turn, was for me the real crux of this, and I thought the greatest argument for this, that the Supreme Court judges need to have front and centre of their mind. I do not know. Obviously, they are going to make their judgment on matters of law. They're the best people in the country for doing so, and they will absolutely make the right judgment, whatever it is. I can't say that. But this argument is brilliant. He said, so at the moment, we're in a situation where Boris Johnson is prorogued for 5 weeks. There is a suggestion that when they come back, they'll come back for just a few days and they'll prorogue him again for the rest of October. And there'll be nothing to stop him if the Supreme Court doesn't. So then Panik said, is pretty much his closing statement, so let's say the Prime Minister wanted to prorogue for 6 months or a year. What then? What then? What would there be to stop him? If the Supreme Court say that it is lawful to prorogue Parliament specifically for the purpose of frustrating the political will in Parliament, for preventing scrutiny of the government by Parliament, which is what it's duty to do, and it can do it for any period of time it likes and whenever it likes, what is there to stop him doing that? Nothing. And he made a reference to A.V. Dicey, who, I talked about this before a little bit, is basically, is in Victorian times, I think, is the reason why the High Court in England and Wales couldn't find against the government, because of a precedent set in Victorian times by an idiot, basically. But here's where we've got some hope. This is why the Court of Session were able to find against the government, because they're not bound by that stupid precedent, but neither are the Supreme Court. And that's where the great hope is. So, then it became Keen QC for the government. So their main arguments, first of all, they were, again, their only argument really, which is why some of their arguments didn't come across very strongly this afternoon. Their only argument is that it's got nothing to do with the judges, got nothing to do with the court. They can't really argue against a lot of the facts. They can't really argue about the skullduggery. They can try. But ultimately, their main argument and the only argument they have is it's not an issue of law, is what they are hoping they can convince them. So they first of all, talked about the Court of Session. They were talking about the fact that the inner house accepted that there was a principle of non-justiciability. In other words, although they decided that they could judge on it, they did accept that it was potentially, I think, a tricky question, which means it would be an equally tricky question for the Supreme Court. And because the book stops with the Supreme Court, well, there you go. Now, Lady Hale, as I say, the president of the panel, was suggesting that the court might not need to decide that rather complicated question. It all sort of depends. And then Lord Kerr asked the government's advocate, what would happen if the court declared prorogation unlawful? Keane said that the Prime Minister would ask the Queen to recall Parliament. Now, whether you believe that is another matter. And just because this advocate is saying it in court, that won't hold any weight. This advocate is not lying in court, that's pretty clear. They will genuinely believe that because Boris Johnson will have told them that. But of course, he might have lied to the council. But anyway, the advocate said that the Prime Minister would recall Parliament. But then Kerr said, might the Prime Minister prorogue again? To which Keane had to say, I don't know. So in other words, he might recall Parliament and then immediately suspend them again. Although hopefully not for... But he'll probably still try and take the piss, won't he? Then Lady Arden and Lord Reid, it was saying, questioned Kerr about the procedural steps to the government, what the government would take if the court does declare prorogation unlawful. I don't think they had any very clear idea about that. But then why would they? Boris Johnson is playing everything off the hip anyway, isn't he? He's not really thinking this through. Now, at this point, Joe Maugham, who was not the QC attending proceedings today, but obviously watching them, he was the guy who won the case at the Court of Session. And he was saying that at this point there were three problems with the government's point. The first one, a prorogation does not need to be on notice. The second one is, how does it go to justiciability? They've got to try and prove that the Supreme Court has no jurisdiction here. And three, that there is an uncontradicted evidence that Parliament could not have used the lever that they talked about. So they talked about the fact that Parliament had a way to stop prorogation. They could have accepted Boris Johnson's offer of a general election. But actually that wouldn't have stopped it. That's a ridiculous thing. And also, you know, that still had the effect quite clearly to shut Parliament down. Except shut it down even worse. That's worse than prorogation. That would be complete dissolution of Parliament. So, yeah. That isn't, we know that's not going to wash. I'm not an expert on the law, but that is not going to wash. So then Keane was trying to say that the power to prorogue Parliament is not limited to preparing for a new Queen's speech. So what they're saying is it doesn't even matter whether you believe Boris Johnson needs the time to prepare a new Queen's speech, because they know that's not true. All of these judges are in the House of Lords. They know how long is needed to prepare a Queen's speech. It's a few days. So they know they're not going to buy that. So this QC was trying to say, actually, there are other reasons for proroguing as well. It doesn't just have to be prepare a Queen's speech. And Lord Kerr was saying, you know, when he tried to bring up a precedent again, what was the purpose of the prorogation in this case? Keane said he was going to come to it. And he said he talked about the fact that there were examples of lengthy prorogations that Panik dismissed as irrelevant. So the ones he talked about earlier on. He said the 1949 one was for party political purpose. However, Hale, the president of the panel, said, but actually on that particular occasion, it was to enforce the will of the Commons. So that was a complete clanger being dropped, an absolute clanger by the government QC there. They specifically used an example of where a prorogation period was quite long to try and defend Boris Johnson's, but using a case where it was actually used to enforce the will of the House of Commons. Completely opposite. So that was just silly. And then, you know, they... again, he was coming back to the Court of Session and trying to say that although they acknowledge the principle of non-justiciability, you know, the idea that maybe judges don't get to rule on these things, that they didn't apply that. They thought they could identify, he said, a purpose in the prorogation. But Keane argued then that that the Prime Minister's reasons for prorogation were apparent from the documents produced in the Miller litigation in the High Court. Yes, they were. They were apparent. It was to frustrate Parliament. That's what came through on those documents. I mean, I couldn't believe it when they brought those documents before the High Court. So then he was what was he doing then at that point? I'm just trying to read my notes. He says, so yeah, then they came on to the issue about, do the documents explain why 5 weeks was needed? So then Keane said, because it included the conferences. So the Tories have been trying to push this idea that, oh, it's not really 5 weeks, it's really just 1 week, because there's 4 weeks when Parliament's not going to be sitting for the party conferences. Now, generally speaking, at this time of year, yeah, Parliament rises for the party conferences. However, they have not, that's not something the Prime Minister decides, and it's not set in stone, it's not on a calendar. Parliament votes for this or not. Earlier this year, there was a break that Parliament cut short, a recess that they cut short. And they were saying they would do the same thing again. The bottom line is Parliament had not voted to go on break for for party conference recess. So I do not think that they can use that it's for the conferences. Parliament hadn't voted for it. Therefore, it is a 5-week prorogation, not a 1-week prorogation. So Keane was arguing that there's no... when it comes back to the witness statement as well, he was arguing that there's no need for the Prime Minister to make a witness statement because the documents provided to the court spoke for themselves. I talked about that earlier. My view on that one is because he doesn't want to write a witness statement, because then if he's found to be lying in it, he's going to jail. That's all there is to it. It's a serious criminal offence, especially for the Supreme Court, I imagine. So then, in terms of the prorogation thing, Lord Kerr came onto the thing, why did the prorogation need to include the conference period? Because at this point, there's sort of 3 ways you can look at it. I mean, there's the way I've looked at it, which is Parliament actually didn't vote for the conference rise in the first place. Secondly, you could say, so why not recall Parliament during this recess to prorogue Parliament towards the end of it? And then thirdly, could you actually just wait for the conference season to be over and then prorogue? So Keane, in answering that, said that Lord Drummond-Young thought that Parliament could reconvene itself during the recess, and that there were others that agreed with that as well, some legal experts. But Keane said that they can't do that. Standing Order 13 says the Commons can only be recalled at the request of the Executive and if in the national interest. Now, maybe that's a clinching argument to why it can't be reconvened in the middle of the conference period. One of the other reasons I've gone through already, Parliament had not voted to. They tried to say, Keane tried to say that there was no evidence that Parliament wasn't going to rise for conference. I would say and actually even the judges said actually there is, because there were some statements made before prorogation to the effect that they weren't going to do it. I've heard that as well. But you could turn it on its head. You could say there's no evidence that they were going to vote for a rise. Because you can't just cite precedent there. You can't just say, well, actually, I think you'll find every year they do vote to rise. Yeah, every year we don't have Brexit on our doorstep. This is the first year where there's a constitutional crisis weeks away. Little bit different. You cannot assume that they would have voted to rise at all. And then on the last point, so then they were basically asked, couldn't Parliament have been prorogued after the conferences? To which I don't think Keane was able to argue against that case. So that's pretty much the arguments for and against. There you go. Hopefully you brought up today on the first day. Like I said, if the second day is just as interesting, or even if it's moderately interesting, I'll certainly do a video. I've got plenty of time on Wednesday and Thursday evening to be able to do that and to get it out earlier than I could on this one. Sorry about that. But otherwise, if it's a boring day, I won't burden you with it. There's plenty of other things to talk about as well. So I hope you found the video interesting. If you'd like to support the channel further, then please click the Patreon link for details. And until next time, I'll see you later.